Morning, everybody. Welcome to the House Committee on Government Operations and Military Affairs. This Wednesday, February 7th, we are picking up our work with a new draft of our miscellaneous ethics bill. So, Mr. Devlin, would you like to? It says here, I think it might make sense to maybe start with the summary and then we can kind of dig into the language itself.
That sounds good
For you.
Thank you for having me, Chair McCarthy. For the record, my name is Tim, Legislative Counsel. For you, the committee members will have draft 2.7 of the committee bill having to do with miscellaneous ethics. For references is 24-0229 and bill summary as well. And the bill summary now includes a little bit extra information about existing disclosure requirements in the front page. And then anything that has changed since draft 1.4 that the committee was reviewing in previous weeks has been indicated in green text on the summary. So it's easy just to kind of skim for, hopefully easy to skim for exactly what has been updated here. Chair McCarthy, would you like me to work my way systematically through the summary to hit all aspects of the bill again, or really just what's been updated since?
Yeah, so I think it would probably make sense because we've been focused on many other things to just do a quick high level on what's in the whole draft, because I think many of us may have kind of, forgotten that certain elements, but the review will not be a waste of time.
Okay. I'll just start off very high level with the purpose of the bill. This bill proposes to, one, require that certain county officers, both running for and holding office, file financial disclosures. Two, modify disclosure requirements for certain elected officers, both running for and holding office. Three, creating penalties for delinquent disclosures for candidates and for state office, county office, and state senators and state representatives. Four, granting the State Ethics Commission powers to investigate, hold hearings, and issue warnings, reprimands, and recommended actions. Five, create a full-time exempt legal counsel position in the State Ethics Commission and reclassify the executive director of the State Ethics Commission from a part-time to a full-time exempt state employee. And finally, add a member to the State Ethics Commission to be appointed by the Vermont League of Cities and Towns. Jumping to the top of page 2 of the summary, part 1 of the bill pertains to candidate financial disclosure requirements. Section 1 and amends, we now turn to the elections title, Title 17 VSA 2414, titled Candidates for State and Legislative Office Disclosure Form. And this will require candidates for county offices to submit financial disclosure forms in addition to candidates for state offices in the General Assembly. Here, and this is an updated portion of the language, county office will mean assistant judge of the Superior Court, high bailiff, judge of probate, sheriff, and state's attorney. So those elected appointed offices.
Right. So this updated draft has all of the elected county offices on. The candidates for those offices are included in the financial disclosure. So we're just capturing everybody who's running for office for those county seats, in addition to us and statewide candidates, et cetera.
Right.
Representative.
Thank you. Remind me where the appointed folks lie. Do they have something within another statute? Sorry.
The appointed folks, I was thinking about a little bit more, and considering this is for candidates, this is the elections title, where candidates would be running. That would make more sense. They wouldn't be, they're not running, so they wouldn't be queued to offer disclosures.
During the course, yeah, right.
The state officers to provide annual disclosures. Okay. However, the county level appointed positions, I'll double check. I don't think that actually applies to those folks in this current draft, though, but I can look into that.
So do you not think county appointed officials, if there are even any, have to file disclosures?
Not all of the appointed county officials, really, their duties don't pertain to fiscal matters. To what degree that matters or not, leave to the committee to determine whether they'd like to ask for disclosures from those individuals, but county clerks kind of deal with recounts. Let's see, the county officer is actually a contracted job, interestingly. It's not actually a held position, it's kind of tasked out. That's good, the other county positions. I can certainly look into that, though, if you'd like some more.
Okay, thanks. I just wasn't sure who was covered under this county umbrella. So it's not appointed people.
Section A of, sorry, subsection A of section 1 will require these those disclosures to include, and I have 7 bullets here. 1, sources of personal income of more than $5,000 from an employer. This is in current statute. 2, if self-employed, sources of personal income from, 2 sub-bullets here. A, the name of any client.
Tim, could you, it looked to me like you started out on one document. Now I don't know where you are
Sorry, I'm at the top of page 2 of the summary.
of this summer.
Yes.
Yeah, so it might have been confusing because you started off with the bullet point from page 1, and then you skipped the existing duties and existing stuff, which is fine because we're talking about everything that's in the bill, but that's a good point of just orienting everybody. So we're on the top of page 2 of the summary.
And
Thanks.
apologies for that. And if any committee members would like me to dive into the actual language themselves, I'd be happy to, and I can refer everybody where exactly. Subsection A, let's see. So the second item that will be required for disclosure forms, if self-employed, sources of personal income from A, the names of any client whom the candidate knows has business before any municipal or state office, department, or agency during the previous 12 months, provided that the disclosed information is not confidential information. So there's 2 things in green there, 2 qualifying aspects that the candidate is aware that their client had business before municipal or state office, department, or agency within the previous 12 months. And also there's a confidentiality element to it now where if they're otherwise prohibited from disclosing that, they would be exempt from doing so in that context. B, if self-employed, sources of personal income from, the names of clients from whom the candidate has received $10,000 or more in the previous 12 months, provided that the disclosed information is not confidential information. So again, that qualifier for confidential information. The third disclosure requirement, and this has been updated in the bill, is membership and position on any board or commission in the prior 12 months.
So I'm going to pause on that one in particular. So in the last draft of the bill, we're going from the current requirement, which is that boards and commissions that receive any state funds, so organizations that receive state funds, if you're on a board, you have to report that already. And then the original suggested language said, in addition to that, any boards that might advise on the spending of state funds. So if you're on an advisory council, for instance, and I think there was some confusion around that. We had a committee discussion about it. And my recommendation to legislative council was, let's just say if you're on a board, just report that you're on a board. Just make it easy, like have the statute just, so any board or commission that you're on that has to do with state spending, so that we've simplified the language significantly in the draft.
The next requirement for disclosure is number 4, loans made to a company if the candidate owned more than 10% of the company, and if the loan was not commercially reasonable and made in the ordinary course of business. This has not changed since the last update or since the last version. Next, 5, companies in which the candidate.
Violence.
Just to like clarify, and I know it hasn't changed, so loans made to a company, the candidate puts 10% more. And if, so does that trigger disclosure with the and if?
Let me pull up the actual language here. So this is the bill. We're on page 3. Okay. So this is 3B.
It's the if that's thrown, yeah.
Yes. And that'd be details of a loan to a political company in Division A of C of not commercially, that is not commercially reasonable loan. Okay, so it'd have to be owned by a 10% in ownership interest, and then also it'd be and. So it'd be both the 10% and if it's commercially unreasonable. Sorry, not sure if that.
So who decides if it's not commercially reasonable?
That, the idea of commercially reasonable loan, is not spelled out here. Because it's not spelled out, it could be litigated by the courts. We could introduce further detail as to what exactly is meant by that. I'd have to check to see if, there's a broader understanding throughout this title of what is commercially reasonable in financial disclosures, or perhaps if it has been litigated, but I could certainly look into that.
That would, yeah.
Yeah, so I'm gonna come back to this when we have executive director separate, because I feel like this particular provision has, I think it's gotten a lot of attention, and I'm not exactly sure how valuable it is. It seems like a pretty rare thing, but we're in any of these provisions, my understanding is we're talking about what's going to be on the form, and every single candidate is going to have to make a disclosure. And if they fail to report something, it's not as if the Ethics Commission is like investigating the veracity of all of the financial disclosure forms. It's an opportunity for candidates to make these things that are required to be on the form public. And if, to the best of their knowledge and ability, they in good faith make a disclosure, and it's not as if there's like an enforcement mechanism that goes through each and everything that's disclosed. It's about what's on the form, and does the candidate for office actually, truthfully and in good faith fill out the form. I don't know that, I think sometimes we're getting a little bit like, I just wouldn't want any of us to get confused when we have legislative counsel say, I'm not sure that's been litigated. I mean, I don't know that in Vermont, really, any of these things have been litigated beyond like an advisory opinion about whether a particular thing may or may not have been a conflict of interest or something like that. I mean,
I think this particular case, the definition of commercially reasonable also is going to change depending on circumstances. So like at some points in time, an interest rate of 2% is going to be reasonable. And at some points in time, it's not, right? It depends on what's going on in the market at that point in time. But there are references out there to look, but it's really going to be that dependent on the point in time that it happened, what are the circumstances. And so it's not really easy just to say, like, define commercially reasonable, here, because it's always going to be back dependent, but it's something that people can ask us about. And it's also something that come up when we're doing FAQs or some of the things for the financial disclosures. It's a question that we try to address in advance in place.
Okay. So subsection A, I'll continue there, will also require disclosure of, let's see, this is bullet 5, companies in which the candidate had an ownership or controlling interest in the previous 12 months that has had business with the state or a municipality. That has not changed since the last draft. The next point has, though, and it's indicating green text here, disclosure will require a description, but not amount, of publicly traded assets and interests in trusts valued at $25,000 or more, and municipal bonds issued in the state of Vermont of any value. These are to be reported to the best of the candidate's knowledge, which permits a candidate to describe blind trusts and similar assets likely unknown to an investor.
Representative Hancock, question.
So how did that dollar value get changed? What was the basis for changing that and why 25,000?
So the original draft had 10.
Right,
The conversation we had in the committee seemed to suggest that folks felt that that threshold was low. So Representative Waters Evans and I, after listening to the tenor of the conversation here, and I had, I think, probably at least implied that we were going to change this in the next draft. There are sort of two big things here, unless I'm mistaken, Tim. One is we increased from the original draft to $25,000 being the threshold, and then we made it really explicit that you don't have to report the amount. So, Tim, correct me if I'm wrong, the way this would work now is the form would say, that if you have any individual holdings above $25,000 or interest in a trust, et cetera, that you would have to report the fact of that. So let's say I had, 4 individual stocks. They might be $200,000 of one stock and $25,001 of another stock, 500,000 of another, and $1 million in another holding. And I would just report company A, company B, company C, company D, and all the public would know is that I happen to have holdings in 4 companies that were likely, in the implications that they're in excess of that threshold. So one argument that I'd be really open to is going back to the $10,000 threshold since we've gotten rid of the amount, because then actually the implication is that you may only have $10,000 of that stock. But what we were trying to do after the conversation we had here was just make this less tedious. Okay. I think the implication that anybody's going to be, legislating or doing something that's potentially a conflict of interest because they happen to have a individual stock holding of $10,000 is that, to me, that's not a super credible implication from all of this. But I think the idea here is that we're just trying to find a reasonable bottom threshold for what that is. And, I personally would be comfortable with 10,000 or 25,000, but we just picked a number that was one of the other benchmarks from, other states that was higher than 10,000 because of some of the feedback that we got from the original draft.
so is that correct that you wouldn't have to report the dollar amount? I think Representative McCarthy was questioning that, so that's correct. I didn't follow your reasoning for going back to the 10,000.
So the idea here is at how much holding, so what value of an individual holding. So let's say I have Apple stock, for instance, and I've got $15,000 worth of it. We have a $25,000 threshold, then I wouldn't have to put Apple on the form. The way this is constructed, the language now, it's really clear. I don't have to put the amount regardless. But the implication, if I write Apple down to anyone reading the form, because the threshold is 25,000, would be that I have $25,000 or more in Apple. So I actually think if one of our concerns is about, candidates for the General Assembly, for instance, feeling like, gosh, I really want to tell everybody about my personal finances, I actually think there's an argument to be made that if we make the threshold on the lower side and there's kind of more disclosure of individual holdings, for instance, but you're saying a lot less about what the value of those things is if the threshold's lower, because if I write Apple on there and the threshold's 25, then I'm really implying I've got at least 25,000 of that particular individual holding.
I totally see what you're saying now. However, you are getting more information out of people if the threshold goes back down to 10,000. And frankly, I think 25,000 is pretty low also. So you are getting more information on people, right? If you drop the threshold back down to 10,000. So I guess I still don't really see the dollar amounts being relevant, except the lower the dollar amount, the more you find out about a candidate. I think, and I know I've said this before, that if you have a candidate who has like 80% of their holdings in a particular company, maybe that's somebody you should be concerned about. Maybe the public needs to know that kind of information, because that's almost like having a controlling interest in a company. It's a similar concept in my mind. I mean, you may not, if you have 80% of your holdings in Microsoft, you're not really a controlling interest in that company, but it shows that that's something that you're really interested in and really trying to make a profit on. I don't really like these dollar amounts. I don't think they're truly relevant to what you're trying to get at, because folks who have $10,000 in a stock, I mean, at some of the stock prices that are out there, they're hundreds of dollars per share. So you could get up to $10,000 or even $25,000 pretty quickly.
Right.
And what does that tell you about that person? That person doesn't have a controlling interest in the company, likely. Unless it's a very small company with very low value of stock. So I don't think you're getting the kind of information that you really want out of this. You really want to know if somebody's going to be sitting here in my seat at this table making decisions based on their personal holdings. And I really don't think this type of picky threshold is going to tell you that kind of information.
So I think we'll maybe put a pin in this. I know it's been like one of the big topics of conversation. So when we have Director Sivert back up, we'll hear from her and TJ about sort of the rationale behind the thresholds and what we're really getting at. Because I think it's what we keep coming back to as people who are candidates ourselves, and we and people who run in the future, if we pass this, will be asked to make these disclosures. I think it's really hard for us to step outside of this and say, hey, what is a reasonable amount of disclosure that we make so that the public can have faith that we're serving the public interests and not our own financial interests. So it's not just about the controlling interest in a company. It's also about, would I be trying to make decisions, or is there even the appearance that I might be making decisions in my role as not just a member of the General Assembly, but also, a secretary in an administration? Where there might be a conflict between my personal financial interests, even if I don't have a controlling interest in a company, I may have, significant investment. And if I just disclose what my holdings are from the outset and everybody does that uniformly, the thresholds are more about just setting a reasonable floor for when it would be relevant, and how granular we need to get. And I think there's a very reasonable debate on what actually makes sense in terms of that threshold, which is why we, in this new draft, suggested a higher floor for that disclosure on the individual holdings.
Thank you. Before I forget my train of thought, would you mind if I just made a couple of comments?
No, go ahead.
Thank you. So I really do feel like our position as elected representatives in the General Assembly is quite different than someone who serves, like, for instance, as a secretary or commissioner in the executive branch, because of the decision-making power that we have versus those people who may be signing contracts. And secondly, I think we should be, and this is really where I'm going with this. I think we should be much, much more concerned about who individual state representatives work for in our outside jobs and who our spouses work for in their outside jobs. Because that, to me, constitutes the biggest conflict of interest in this building, more so than any stock holding or bonds or anything else that anybody could possibly be forced to disclose. I see so many conflicts that maybe they aren't really happening, but the appearance of. And optics are everything in this job. And if you want us to be truly transparent, we should know who works for a company that has a distinct interest in the type of legislation that we're passing in this building. So that's what I'm where I'm coming from on this. And this legislation this legislation to me does not address that issue at all.
So Sam, in current law, I think one of the reasons we don't see that reference is that right now, any source of income that you or your spouse or domestic partner has that's above $5,000 has to be, is required to be reported now under current law. Isn't that correct?
That is correct, as well as employment, including the employer or business name and address.
So currently, like the candidate spouse needs to be listed where they get their income from.
Yes, the candidate together with his or her spouse or domestic partner that totals more than 5,000.
Okay, forgive me because it's been 2 years since an election that I don't remember this, but so that's good. That's good to know that that already exists.
Yeah. That's just why we haven't talked about it much,
But
just because it's part of the current.
I feel like none of that is ever really investigated by anybody. You might have to report it, but when we're talking about the powers of investigation and potential censure, that's where it gets a little bit vague to me because I don't really see that it makes much of a difference that you're disclosing it. So why force people to disclose their personal information if it's not going to be acted on? I really do feel that people's financial information is quite personal. And I feel like this is maybe a little bit of overreach in terms of people's personal liberty, but that's the position I come from. You know, just by virtue of my political background. So that's all I'm going to say.
So, gonna make didn't want to have this out, but I feel like it's illustrative of why disclosure is important and sort of how it plays out. So, when I was first in the State House, my employer was disclosed, and a bill came up that was about the entire net metering policy for the whole state. And I voted for that bill on the floor along with something like 126 other people in the House, right? And there was a good government group who complained to the Speaker of the House and the House Ethics Panel that I shouldn't have taken that vote. And the Ethics Committee in the House looked at it and said, there's no conflict of interest here because that particular bill, that vote, in fact, affected everybody. It's the same way that when a teacher votes on an education bill, like we have a citizen legislature, we have to be able to come here. And as long as a bill doesn't impact a particular person's business any differently than it would their competitor or a group that they're in, that's not a conflict of interest. But it's really up for the voters to decide. And if I didn't have to disclose who my employer was or who my clients were, then there wouldn't be that opportunity for the public to be able to decide for themselves, regardless of what the ethics panel decided, whether or not the conflict mattered. And so I think you're getting at some things Representative Hango about how much do we as servants of the public and people who are seeking the public trust need to put our personal information out on the line. So we took some steps a few years ago, starting to require a little bit more financial disclosure, person and their spouse. We've set up the State Ethics Commission, their statewide conflict of interest policy that governs the General Assembly and the executive branch. But the whole reason we're here with this bill is that we are still, according to a letter that we got, I think we all got, but I got from that same group that actually sent me, that complained about my vote on the net metering bill 10 years ago. That same group is saying, pass this bill because in the interests of the public, they want the public to know more about us than we currently disclose. And so finding out, it's our job here to figure out where those lines are. And it is really hard. I mean, and it feels like a lot more. And I think the more transparent we are, to a reasonable degree, like I really don't think that we should have to disclose our 1040s. And that's why that's not on the table here today. I think, the Ethics Commission didn't put that in their recommendations for the General Assembly. But when you start to get up to running for statewide office, we already, decided that that was going to be a reasonable disclosure. So these are all really good conversations to have about what the level of specificity is.
Yeah, I really appreciate you bringing up that example because yes, we did all get that letter and I don't totally agree with those folks. I'm a little bit of an outlier there. And I'm sure they would hope that I agreed with them 100%, but I don't really. So, but I do appreciate you giving a real life example of that. And that is one of my frustrations here is that probably someone in that position should have just recused themselves from the vote on, what is it, Rule 75 or something like that. And honestly, I'm not saying that to you personally, anybody in that situation, but I know that the state ethics group or the ethics group here in the General Assembly said that it was okay. I don't necessarily agree with that either, but there's a lot that I don't agree with in this building, so we'll just move on.
So totally understand. So I have a few hands up. Let me go Representative Waters Evans.
Thanks. I just wanted to first acknowledge that 100% it feels strange to have to disclose something that's really private and personal, just in order to do something that seems like you're also giving up a lot of things that are private and personal to be here for a lot of people, right? But the other thing I wanted to mention is I just remembered if you look on our witness list and you look up Christina Siverett underneath her name with all the documents, there's one from January 24th. That's a state financial disclosure chart. And it's interesting to look at because it breaks it down every state and what they ask for from different. Do you remember seeing that? I had kind of forgotten about it. So some states are no, but then some of them are $1,000. So in that context, 25 seems pretty high, I think appropriately high in this case, but they're pretty low, like 1,000 and 5,000 for all the states that do have disclosure limits for investments or thresholds for investments. So just for some context.
Yeah, I think if you look at a lot of those states, they're larger in population than we are, and they have more
We're the
people to gather candidates from. We're such a small state.
Yeah.
And it feels more personal, like a lot of people who run for office across the state, I know who they are. Do I really need to know that personal information about them? I don't know. But like if I lived in Arizona, for instance, I wouldn't know a lot of those people who are running for state representative there. So it would be less personal and more just like a business thing. I think we try to do a lot of things in this building that, and this is something else I've really been wanting to say, we try to do a lot of things in this building that are like other states. We follow the model of Colorado, Oregon, Washington State, California a lot. Those states are so much bigger than us population wise. We can't really compare ourselves to them. So I know there are some smaller states on this list and I know what their limits are, what they are, but I'm not one to just say, okay, let's follow the Rhode Island model. For instance, I just want us to be Vermont and be unique and be as transparent as we have to be. I don't want to go overboard. Like one of the questions I asked that had to do with the number 3 that we just changed membership and position on any board. It was originally saying any board you serve on that does whatever or receives or makes decisions on money coming from the state. We didn't have any. When I asked for an example of that, nobody could give me an example of one of those boards that we might sit on. But other states have them that just specifically take the money that comes from the state and allocate it around. But we didn't have one of those boards that you would sit on. Do you know what I was talking
thought
about?
We gave a couple of examples, most
I don't think
specifically the
anybody could come
opioid settlement
with
funds.
Okay, maybe, maybe I wasn't
Gave
here
very
for that,
specific examples during that testimony.
that
That was the
overall.
one that sticks out
Okay.
on the top of my mind, and a really obvious example.
But there were a couple.
There were,
Yeah,
okay.
there's $50 million or more actually.
Okay.
Yeah.
Well, then I will retract that statement, just say that I'm not somebody who says, oh, let's just follow the model of another state. I really want to.
Oh, it was more for context.
Where we're coming from and why we're going there, and why does this apply to, have we had issues with state representatives who have holdings that need to be disclosed and haven't been? And I don't know of any right now, but if anybody can come up with some specific examples that would help me, that would be great.
I think the overarching thing is it would be hard to know if we had issues without having a disclosure culture that's similar across the board.
So how did we get here to wanting to legislate a problem that we haven't figured out exists?
So what I would say, without getting too deep into the cases, and it may be important for us to perhaps have some more people in, and I'm sure Executive Director Sievert can speak to this, but the State Ethics Commission gets a lot of complaints about perceived conflict of interest, and right now, we've really been focusing much of our discussion here on the disclosure pieces, because I think, there's a lot of agita about how much we have to disclose as public officials when we run for office or hold office. But a big piece of this is for them to have the ability to actually respond, to have a little bit more staff, have the ability to have hearings so that they can respond to the complaints that they're already getting, where right now they mostly have to say, we don't have the power to dig into that. We, can issue an advisory opinion on if something like that is actually true, whether or not it would be a true conflict. But I think one of the more important things, even then beyond disclosure, that we're going to hear in the next parts of the bill is about, how much power do we want the State Ethics Commission to have to actually deal with the very real complaints from Vermonters about whether or not officials in, we've talked a little bit about local, that piece we're just kind of beginning in the companion language here. But on the statewide bill, we've had a few years now where we've had a pretty consistent conflict of interest, state code of ethics, people across state government know about it. From what we heard from Jay Johnson, the general counsel from the administration, was that they, have even some tighter definitions of things than we've contemplated here. So now that we've all got the experience with that, and the State Ethics Commission is in this quandary, I think it might be good for Director Sievert to give us some examples of the kinds of things that Vermonters are bringing.
Absolutely,
But-
yeah, I would appreciate that.
Yeah, I think that's where the idea of advancing this is, to not only be able to deal with those things, but also to be able to say, hey, we take ethics seriously in Vermont. And I think you're absolutely right. We need to right size it for Vermont. But at the beginning of this, I said something to the effect when we first took up this draft language that we've had just kind of we all trust good old, person X that's in state government. And that's been the Vermont way for a long time. It's just to kind of have trust. But so many officials have violated that trust that the reason that other states have gone to this model of kind of a more universal disclosure is to be able to give the public more confidence that everybody's putting their cards on the table about what their interests are. Representative Hooper, go ahead.
Thank you for that little glimpse. It identified for me where I am in this process to some degree. I have no problem whatsoever with the Ethics Commission more investigatory and powers that would allow them to respond to a complaint with an actual investigation. After we cleared up the tax filing issue last time, I have less objection to disclosure. For myself, I don't have any really, but for my wife and blah, 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 blah. I still think that's invasive to somebody that really, you know, I'm not married to Christy Brinkley or anything, but it might be considered invasive on that level, more so than I would want to feel comfortable with. And that's my quandary at this point.
Representative Higley and then Representative Nugent.
Yeah, I don't know if now's the time, but, you know, and just listening to the discussion and stewing over number 2, the self-employment source of. Want to talk about that now, or would you rather wait until the commissioners looked at the fund, or?
Yeah, why don't we, so that we have time to hear from the commissioner, why don't we just breeze through the rest of what the kind of summary changes are? And then I think it would be good for us to have that discussion with the commissioner about some of the, going back over the rationale for some of these pieces. And then, you know, if we seem to have consensus on wanting to modify this draft language further, then we can make those requests for Mr. Zone. That makes sense.
Yeah, no, because I just, like I say, stewing over it, I've got some concerns, you know, addressed to, you know, a small self-employed individual like myself. Great.
Representative,
Just a couple thoughts. I think that like the conflict of interest definition is based in the law. I'm correct. And so there's like a foundation for the reason that it's defined that way. And so it's, to me, that is like not very arbitrary. And then I think like sometimes in this discussion, the protective factor to candidates of being upfront with all this information is kind of lost in the, you know, the moment of potential scrutiny that people have on you, and also the chance to build trust with the public ahead of time by showing them that you trust them with this information. So I actually think it actually like strengthens the political process and our ability to run for office. I appreciate the direction that would go, whatever amount is on there.
so Tim, thank you for indulging us having committee discussion. I think that was good for us, though, to get some concerns on the table. So we'll, I think we were just probably getting into the final changes in part 1. So
Yes. The last item that is requiring these disclosure forms would be number 7, the full name of the candidate's spouse or domestic partner. And that has not changed since the last draft. And right here, I'd just like to quickly note that the same disclosure requirements have been added in section 5 later on in the bill for executive officers and some county officers, those, that is, individuals holding office as well. So it's mirrored in 2 different places. And then subsection C would enable candidates to redact their U.S. individual income tax return form 1040s. On that, the candidate's street address and identifying information and signature of a paid preparer. And again, only state officers, not legislators, have to submit the partially redacted 1040 form.
now that we've added those county officials, we're also not requiring that they're, so it's just statewide candidates or state officers that have to file. That's tax return.
We have more forms than just the 1040 that people use, right?
As far as what's required in the disclosure, or
Well, just as far as filing tax.
depends on the individual, I'm sure. But the only reason we're mentioning this is this just happens to be the being modified as far as what can be redacted here. Part 2 of the bill pertains to in-office financial disclosure requirements, and this is sections 2 through 5. Section 2 will amend 3 VSA 1201 definitions by migrating certain definitions from elsewhere in the chapter to the definitions section, kind of grouping together all the terms to be defined and throughout the chapter. In particular, it will migrate conflict of interest and public servant. There's a new definition for county officer, meaning an individual holding the office of, there's a typo on the summary. I'll update that. The definition of executive officer has been amended to include deputy under a state officer, which in effect will require annual disclosures from deputies of the treasurer, secretary of state, auditor of accounts, and attorney general, in addition to the current agency secretaries and deputies, department commissioners and deputies. So right now, under current statute, the deputies of the essentially the governor's branch of the executive, they're required to file disclosures. This would expand it to the other executives, so and their deputies there. Okay. Let's see, this section also has a definition of government conduct regulated by law. Creating or permitting to persist of any unlawful employment practices pursuant to essentially the fair employment laws, including discrimination and sexual harassment. And this will enable the State Ethics Commission to refer and to track complaints of this conduct. Section 3, again, just migrates that definition of public servants. Section 4 migrates the definition of conflict of interest in the definition section. Section 5, and this has been updated somewhat, will amend 3 VSA, section 1211, executive officers annual disclosure, to require the same additional information to be disclosed for in-office executive officers and county officers as candidates for those offices in section 1 above. That's what I mentioned earlier. There's that mirroring of disclosure requirements for candidates and those in office. Except here, county office in this section will mean the high bailiff and state's attorneys. The difference being that probate judges and assistant judges will have to offer certain information disclosure while running for office, but not while actually in office. Also to note here that sheriffs were given their own conflict of interest and disclosure requirements in Act 30, which was Senate Bill 17 last year. And that's why they're not included here. Part 3 of the bill pertains to delinquent disclosures for candidates for state office, county office, state senate, and state representative. State senator and state representative. Section 6 adds a new section to be 17 VSA 2415. This is in the elections code. To be titled failure to file penalties. And this will be regarding penalties for candidates for state, county, legislative offices who do not properly file their financial disclosures. Subsections A through C will create the penalty structure. Secretary of State will notify the State Ethics Commission, which will issue a notice of delinquency to the candidate. Candidate shall have 5 working days from the date of the issuance of the notice to cure the delinquency, as properly file those disclosures. After which the candidate will pay $10 a day with a maximum penalty going up to $1,000. Awesome.
Senator Water seconds.
Thanks. Can you go through quickly the language in the bill where you say penalties for candidates who do not properly file their financial disclosures?
Sure.
What does properly mean in this context?
Sure. Let me, so section 5, Next here is, sorry, bear with me for a moment. This is on page 15 of the bill. Failure to file penalties. So let's see, the new language in subsection A of 2415 will state, if any disclosure required of a candidate for those offices is not filed in the time and manner set forth in these other cross-referenced sections, and those pertain to the dates in which various offices have to file things for both in various elections. So time, is it on time according to the deadlines, and the manner set forth really gets to the completion of the form for the most part. Making sure you don't, a candidate doesn't leave anything blank for the most part. Presumably would mean a matter of truthfulness as well, to disclose accurate information. As I believe, I can certainly triple check and get you the explicit language of these cross-reference statutes if you like, but I'm fairly certain they say something, there's somewhere in there asking for that the candidate would have to certify that the information being proffered is accurate.
That might be already a part of it.
I think it is.
Yeah. But it doesn't, it's not like there's a penalty if you mistype and you write $14 instead of $15 or something, like it's,
No.
No.
It'd be more like you just didn't hand in your form at all.
got it.
And if you did, maybe there's much of the information is missing. But whether the statute's silent as to, is it one space or 50% of spaces that are blank?
Okay.
Let's see. So section E in part 3, this is section 7, subsection E, sorry, makes any intentionally fraudulent statements on disclosure form a false claim pursuant to 13 PSA 3016, which shall be referred to the Attorney General or State's Attorney for enforcement and represent or as evidence. This kind of gets to maybe a little bit further. This would be egregious conduct here, very much intentionally filing inaccurate information with the purpose of deceiving, making a false statement.
Senator Cooper.
This section seems like it's all pretty much a shall. I know that most of us probably don't hire a professional treasurer, and I know that my personal one has had trouble getting into the Secretary of State's basement a couple of times. Where's the oops, not my fault section in here?
The subsection E, the intentionally fraudulent statements
No.
or the
even 8.
timing filing.
Just the filing date, like deadline.
Sure. You're right. It is it's best to think of it in a shall, as in candidates will be required to submit the materials by the certain deadline, or then be subject to the $10 day fine after the certain process is followed there.
I think what might alleviate Representative Cooper's concern is the process that has to be followed for that. So could you just, we might even want to look at the bill language itself as opposed to the summary to lay that out.
So this is on page 15 of the bill. The process here, to Chair McCarthy's point, is that the Office of Secretary of State will receive the information. They'll be the ones to kind of clock if something hasn't been turned in by a certain deadline. They'll inform the State Ethics Commission, and it will be up to the State Ethics Commission to send out a notice informing the candidate that they haven't provided the requisite forms. There will be a period in which the candidate will be like, oh, okay, let me go ahead and submit that. And if it's submitted and everything is, the information is complete on that, then there's no penalty levied at that point. And the delinquency will be considered cured.
There's Secretary of State says, here are the 50 candidates that haven't submitted a form by the initial deadline. State Ethics Commission provides a notice to those candidates. And then from the time they get the notice, the candidates have, in the current drafting bill, 5 days to cure that delinquency before any penalty can be assessed. And then after that, the State Ethics Commission can reduce or waive any penalty imposed. Tim, I think that's the bottom of 16.
Yes. That, yep, that's right. That's in subdivision 4. The commission may reduce or waive any penalty, let's see, if there's demonstrated good cause, as determined by the State Ethics Commission and their sole discretion.
Yeah, my point is much simpler, I think, than that. My recollection of what has happened in the past is that everybody sort of waits until what you probably classify as the last minute, and then something goes fluid with the Secretary of State's filing system, it's set up basically that now you automatically would get referred to ethics to do the notice and everything else. And if you don't happen to have access to JP real quickly, you're in that loop. I don't know that that's necessarily cognizant of sometimes the systems that we have in Vermont don't work the way they're supposed to.
Yeah, so I think actually in the drafting of the bill, I wasn't too involved in this language, so we can hear from Director Sifrid, and I know Representative Waters Evans was helping to shepherd some of this into draft language, but the idea here is not that I think we're trying to create a mechanism where people get punished. It's that right now, candidates don't take filing seriously. They just don't. And like, I understand that sometimes the technology doesn't work. And that's why there's a cure period. There's the opportunity, if you're really experiencing trouble, that you can say, hey, State Ethics Commission, the IT issues that the Secretary of State's office is having are crazy. And the other thing is, if you don't pay the fine, like what, it's really, in the end, it's sort of public shaming and embarrassment for a candidate who doesn't file. But right now, there's just no mechanism of enforcement at all for the filings. And so there are a lot of candidates who just don't take it seriously. And that is frustrating to so many Vermonters. I mean, we're going to have the Secretary of State's office come in on this tomorrow afternoon. And I think they'll tell us how many times they get complaints from people about, like, I can see that this candidate for office X has lawn signs and advertising and all this stuff. And I go to look for who's funding their campaign and they haven't filed their disclosures. It's just like, it's infuriating to Vermonters. And it makes me feel, as somebody who really does my best to file on time, like, what am I doing this for if half of the other candidates in the state aren't taking it seriously? Representative Chase, go ahead.
I mean, from my part, my second campaign, I didn't do any fundraising or spending, so I didn't know I had to file. And basically skipped an entire election. So I found out that that's not how that is worded. As part of this, can we have the Secretary of State, everybody who's filed and going to be on a primary or whatever ballot, gets a letter from the Secretary of State saying, here are the obligations, what you need to do?
Let's talk to them about that. I mean, I kind of feel like at a certain point, like, you just go on the Secretary of State's website, there's a handbook for a candidate. It explains it very clearly. And so I want to hold that thought, and we should talk to, whether we hear from Lauren or Will tomorrow. I can't remember 100%, but we should talk to the Secretary of State's office about that. If I was going to guess, I'm guessing that what they would say is, like, at a certain point, it kind of needs to be on, like, if you're running for public office, that you at least will visit our website and see what we say you have to do. So that's
Fair enough.
Yeah.
I don't want to put people in a situation where Representative Higley is standing up in front of the Fish and Game Club and one of the wise ass people from somewhere stands up and says, can you tell me how many times you've been referred to the S? Something simple like this. It takes on a life of unless it's an case that doesn't happen.
I guess my thought when you said that is that I don't believe, as Representative McCarthy just said, I don't believe that this is being put in place in order to punish or expose or embarrass or make vulnerable a candidate. I think part of the job is, yeah, people might stand up at a public meeting and say, hey, I saw that you have over $100,000 in Google stock. Why are you voting on this? That's a part of our job. It's part of our life doing this job. And I think I think saying that we shouldn't be held responsible for our own behavior and our own compliance with laws should be put aside for fear of people calling us on it.
And if I may walk over with I'm not going that far. That's not my concern.
Yeah.
I agree with the chair that it's, tantamount to bad guru if you don't file a form and such, but this seems to just be an opportunity for people who, you know, want to file something on the web that says,
Right.
you've been referred 4 or 5 times, and there's no clarification of why. Worst
Well,
case.
Am I wrong, Chair McCarthy, that there wouldn't be a list published of just random, these people are being reported for an ethics violation without saying filed late? Like there's it's not just like a generic,
It's unaddressed at this point.
So we have two different entities, Commission and Ethics Commission and the Secretary of State's office. I'm not sure, this bill does not require the commission to post anything. I am not sure that the Secretary of State's office publishes a list of late recipients. It may appear they would have a database that would be searchable that said, have a line where people would expect to find something at a certain point in time where it may appear blank. That would be an indicator. These are public records as well. So if there's no list, there would still be subject to the Public Records Act to the degree which that, the information may be partially or entirely withheld in full is subject to the exceptions in 1 VSA 317C. But this bill doesn't require either the Secretary of State or Ethics Commission to publish a list of offenders.
But it is not confidential, quote unquote, information and can be probably easily discerned.
Right. There's also the issue of this would be a negative record, right? Because it's the problem is there's an absence of record being produced here.
Yeah, the easiest way to deal with it is just to file your filing, and if you miss it, you've got a cure period, and if you're really having trouble, you can ask the State Ethics Commission, give them good cause, and they can say, oh, we're not going to levy any.
Yeah, and this is for my part anyway, a continuous train of thought that there was an opening place where something didn't go the way it was supposed to, and then all of a sudden you're in this loop of referral, whatever. It doesn't happen often, I imagine, but it certainly happens.
Well, I think that the challenges that candidates have faced with the campaign finance system does create issues. I mean, there are times when it's worked great for almost every filing candidate. And I think we should ask the Secretary of State's office tomorrow. I know that they've made improvements to that over the years, and, kind of how often what percentage of candidates has trouble filing, and how long does it take to fix those issues? Because what we may want to really think about is the cure window too short? Should it be 2 weeks instead of 5 days or something like that? And on the other hand, I think there's a public interest especially during the end of the campaign, in getting that information quickly as possible. And we don't want to just extend that indefinitely. So those are policy decisions that we can make, and we've got a draft in front of us.
Be like an on year, off year, and
No, we should make it one consistent. Is that a 2 cube by half? Yeah.
I'm like, I'm gonna make this easier by making it way more complicated.
I feel like that's an expression people use, so. Okay. All right.
Yes, no. Appreciate it.
All right, so Executive Director Silver, do you want to comment on that?
Yeah, I was just gonna say, one is a plug, so we now have an online filing system for executive officers that the Secretary of State's office can use for financial disclosures for candidates. So I sent around the links if you want to take a look, you can see how easy it could be to file online. But just a second, we're not going after, if you were to miss a filing deadline, we're waiting to get a list of people who are actually late, and then something out that 5 day, I think it's working day notice. And so if you have a reason why you couldn't file on time, that's perfectly, acceptable. That's something that we're gonna say, okay, as long as you get the notice within those 5 days, as long as you can do it, then you're all good. If for some reason you're stopped from doing it because of the technology to, malfunction somewhere else, then again, that's gonna be a reason why you couldn't do it and you wouldn't be fined during that time.
What have we got left that we haven't hit, Mr. Devlin?
Part 4 of the bill has to do with expansion of the State Ethics Commission's powers, and this is where most of the new ink appears in here. The following sections will expand the commission's powers, enabling it to investigate, hold hearings, and make non-binding recommendations. These sections have been updated to provide additional detail process. And you can see there's a lot of green text indicating what has changed. I will skip down to section 10, which adds a new section regarding investigations. It enables the committee to investigate alleged unethical conduct occurring within the prior 2 years. So built-in statute of limitations there, with or without receiving a complaint. Investigations must conclude within 3 months, and it may result in an investigation report and subsequent commission hearing if there is finding that probable cause to believe, that there is probable cause to believe that the public servant's conduct constitutes an unethical violation. New section 11 adds a new section regarding hearings before the commission. This enables the commission to hold public hearings for the purpose of gathering evidence and testimony and making determinations if wanted. Both the public servant and any complainant will be afforded an opportunity to be at the hearing, present evidence, respond to evidence, and argue on all issues related to the alleged unethical misconduct. Section 12 will add a new section having to do with warnings, reprimands, and recommended actions. This enables the commission to issue those warnings, reprimands, and recommended actions within 30 days of the last hearing. The recommendations may include, not be limited to, facilitated mediation, additional training and education, referrals to counseling and wellness support, or other remedial actions. And just like to emphasize that these would be only recommendations. Section 13 adds a new section having to do with procedure and rulemaking. This directs the commission to adopt rules regarding procedural and evidentiary aspects of the investigations and hearings. It also grants the commission the power to issue subpoenas and administer oaths in connection with any investigation or hearings. Typo about correct. Section 14 will add a new section regarding records and confidentiality. And these records relating to the commission's handling of complaints, alleged unethical conduct, investigations, and proceedings are exempt from the Public Records Act and shall be kept confidential. That's the starting place. And then there's exceptions to that, being investigation reports in a hearing, if a hearing is found to be warranted, that is, if there's probable cause determined to be the case. 2, evidence produced in the open and public portions of the commission hearings. I should just note that the commission hearings would be subject to the open meetings law, so there's possibility for those to go into executive session in certain circumstances already spelled out in law. And 3 would additional records exempted from confidentiality, that is, would be public, would be any warnings, reprimands, or recommendations issued by the commission and supporting documents as determined by the commission, so that end product. And I'd like to note here that there is no appeals process, namely because there's no binding final decision, no expulsion from office or fine or loss of property right, et cetera. And that is really that there's nothing to appeal.
Representative Haney.
Thank you. That last note completely threw me. What do you mean there's no binding final decision? Does the commission not issue a decision on their hearings?
They may issue a determination, but the form of which it is that it's a recommendation doesn't have to be followed by the public official. So if they say, so if there's, an issue or a reprimand is just a declaration. And then a recommendation, should it be, let's say, we recommend that there be facilitated mediation between the parties to hash out the differences and find reconciliation on the matter. Neither party has to actually participate in that if they don't want to.
Why do all this if you're not going to come to a conclusion that somebody did something really egregious and needs to take action to rectify that?
Yeah, so I think I'd like to have Executive Director Sivert talk about the sort of virtue of doing this. If you don't want to do it now, that's great. You might as well just do it in context. We've kind of,
I think the idea is that there'd be findings that we base the recommendations on, so there would be a confusion. And so right now, I think the issue, and a lot of people come to us looking for impartiality. And so what we would recommend is a third party impartiality to review the case. And again, we're not working on behalf of the complainant, or not working on behalf of the state to come up with a finding, with a recommendation to an objective investigation, and then come up with findings and recommendations that could then be implemented by someone with the power to enforce, should they so choose.
so for instance, if there was a complainant who was bringing a complaint against an executive branch official, a secretary, deputy commissioner, et cetera, that could go to the Department of Human Resources for an administrative remedy. But you might find facts, make recommendations, you might be able to alleviate concern because, or say that something doesn't rise to the level of conflict of interest potentially. But right now, the way it stands today before this bill, the State Ethics Commission can issue advisory opinions on sort of just the plain request from people, but you don't really have any ability to hold hearings or investigate today, right?
And advisory opinions are only, we can only accept requests from people when it's, the request is about their own behavior. So we can't take them in the form of a complaint. We can't issue an advisory opinion related to complaint. So what this would do is provide a level of transparency when we do have findings that it can be made public. And also just find that third party objectivity that, you know, is missing in the process now that a lot of people are concerned about. So I'm not saying that, you know, people don't investigate complaints currently, not objectively, but I think there's concern out there. Right? But we hear from people who are interested in filing complaints that their complaint won't be treated objectively, that goes directly back to their home agency. So in this scenario, we would handle the investigation and recommendations part, and the home agency would handle the enforcement part.
So who's the home agency and what happens to a state legislator?
So it would go back to the one of the ethics panels.
And then what?
Then we go to the ethics panel.
Which is what they do now, right?
They handle the entire process now, so, you know, to be honest, I'm gonna talk about it a bit later, you know, in the initial stages, we're gonna have to be very careful just in terms of resources about what types of cases we accept for investigation. So we're really gonna be looking at cases where there is no viable referral alternative. I can go through it, I think maybe better when I testify, but for right now, we're gonna be really looking at cases that fall squarely under the code of ethics, rather than, you know, a mix of the code of ethics and other personnel policies or other policies that exist, and where there really is not a viable avenue for impartial investigation. Or no avenue, because there are cases where there's no avenue for investigation or enforcement right now.
I'm still not seeing a solution to whatever problem you're trying to solve. I'm not seeing a problem and I'm not seeing a solution here. So maybe your testimony later will help me.
Put a pin in it and come back to it. Representative Hooper, go ahead.
Yesterday, the people that put pins in us were here in the card room, we should invite them in.
Not pins in us, pins in the idea.
The wording in section 10,
Oh, I actually punctured. There you go. Okay.
the wording in section 10, with or without receiving a complaint, prior to that, unethical behavior is alleged by somebody, something, some entity. This body is going to have the ability to self-police us.
Self-initiate, yes. As currently written, they can receive a complaint and then initiate an investigation. Or if no complaint is received, but for example, something is in the paper, they can take it upon themselves to initiate an investigation.
So Representative Byron shows up in a pink pickup truck, and there's no disclosure on his form that says he's been selling Mary Kay for a while. And
I appreciate the knowledge.
them to do something.
To the extent that that conduct would constitute unethical conduct.
He'd lack of disclosure.
Perhaps, I'm not sure exactly
Yeah.
about the,
Okay.
details of the hypothetical.
And I can say that financial disclosures are rarely investigated while there being some other sort of, so the way that you just described is something that I think the ethics commission would be unlikely to investigate given limited resources and a complaint that would be in a situation where someone initiated an investigation.
Is there a record of the complainants or are they confidential?
Everything is confidential, until there's certain stages, which, certain documents may become, public. Everything is confidential until, after an investigation is completed. Then if the commission determines that a hearing is warranted, then an investigation report is drafted and that is made public. And also notices, provided to the, parties as ones are going to come, be scheduled, but those would be public as well. Then but if it's, if no hearing is warranted, then the parties are notified, but everything else remains confidential. It's exempt from the Public Records Act. Similarly for the hearing, hearings are public, with the potential of some of the hearings being conducted in executive session, much like regular open meetings law, public records would kind of interplay as normal there. So any evidence introduced public, how could you keep that the reps? Then any recommendations would also be public record as well. But the de facto here is set as confidential. And actually there's some preambulatory language that gets to the confidentiality. And that is on, sorry, later part of the bill. This is, here we are, page 26. That speaks to the intent. There is an intent section. This is section 14, 3 VSA 2131, new section to be added. And it's okay with the chair. I'll just read through this here. I think it provides some good context for this conversation here. Is the intent of this section to both protect the reputation of public servants from public disclosure of frivolous complaints against them and to fulfill the public's right to know any unethical conduct committed by a public servant that results in issued warnings, reprimands, or recommended actions. And then we get into the substance of the law beneath that.
Thank you.
Let's see, and then I should just say quickly that the remainder of the bill, parts 5 through 9, have been unchanged with the exception of section 18, which is adds what's almost, I think, really a technical correction. It's just correcting a statutory cross reference, and that. But I'd be happy to go through that to share with you.
Yes, what I think I'd like to do is just take 10 minutes or so before we break and switch gears to have Executive Director Sivert maybe respond to some of the thoughts that we had today. And then we're going to pick this back up tomorrow afternoon with the Secretary of State's office coming in and can dive into it more then. Chris, would you like to switch places with Mr. Devlin? And if we got deeper into the weeds on some of the stuff than I thought we would today, but going over the draft, but I think it was important to get some of the concerns on the table. So feels like a bit of a slog, but I think we're making progress here on at least identifying where the spots are that we're going to have to.
I'll try and be quick, and TJ is also here, I think, to answer questions as well. And so I just say, when it comes to financial disclosure language, I think that we didn't really have any comments on the changes. We think it looks pretty good. Our 2 minor comments would just be $25,000 is on the high side. So if you were to consider anything, I might consider lowering it a bit because $10,000 tends to be the upper limit. And also there's some language that talks about when it comes to disclosing, let's see, investments held by a candidate or the candidate's spouse or to the best of the candidate's knowledge. The phrasing could kind of create a loophole where people are saying, well, I'm not going to open my wealth statements this year from the broker, so therefore I don't know. So we would suggest potentially tightening up that language a little bit. And TJ has some examples, but I think talking about, the concept of impossibility, also the legal concept of known or should have known, just so that we're not creating a situation where people can quite easily get out of that by just deciding proactively not to look into their finances, or, and choosing not to talk to my spouse about this particular matter. So those were really our only comments when it came to the financial disclosure language. I'll say that we're really happy to see that county office now includes the offices of assistant judge, high bailiff, and probate judge. We don't think that there should be exceptions to financial disclosure if you're covering one category of candidate. In this case, candidates for county office. It should count everyone. And I can give you actually an example, because I know people were looking for examples or financial disclosures can be useful. So about a year ago, we did get a complaint from somebody, a tenant in a multi-unit building. Their building had been purchased by a new landlord who was creating conditions where they felt were trying to drive the existing tenants out who had lived there for a long time so that they could raise the rent. And the tenants were considering bringing a lawsuit against the landlord for the conditions that existed. And apparently the landlord repeatedly referenced a local judge who was his business partner, whether it was in this particular endeavor or not in this particular endeavor, we don't know. Was he really a business partner? We don't know, but they used that repeatedly as a threat. It's telling this person, according to the person who called me, that if you bring this lawsuit, it's not going to go anywhere because it's either going to go before the judge who's my business partner, or he just knows everyone in the courthouse, and so they're not going to do anything with it. Whether this was, a valid thing that this person was saying, whether there was truth behind what the landlord was saying, we just don't know. But if there had been a financial disclosure out there that was publicly available, then at least we would have known whether we'd have some clues as to whether there was merit to statements that the landlord was making. So moving on,
Before you move on the financial disclosure piece, I know Representative Higley had a question about specifically about for self-employed people. I think the concern is around the client language on the disclosure.
Right, and thank you. And I appreciate that we put in there for whom the candidate knows. Because, in my small business as a contractor, I definitely don't question an individual who possibly gets a job for over $10,000 and say, do you have any? So I'm glad to see that piece. I think, that piece is in there for other folks. It could certainly be a way out to say, I didn't know. And then going down to section B, naming the client who I have received $10,000 or more on a job. I guess the first question I ask is, what good would just a person's name do? And I guess second of all, I can give you an example, maybe if I had to divulge an individual's name, what right does that individual have to say that they don't want their name divulged? And I can maybe give you an example of an individual who was very low income, had a grant to have all their windows and doors replaced in their job, or was going to do the job. And if I told them that I would have to disclose their name in regards to that job, and they said, I don't want people knowing that I had a grant because of my low income to replace all the doors and windows.
right. And I'd say, that type of situation where they're a grant recipient, well, I don't want to get ahead of myself. TJ, do you have anything that you'd like to say there? Because I think you're more of an expert than I am when it comes to these kind of questions.
No, and that's an excellent question. The way that other states have dealt with that is to have carve outs for confidentiality if those types of circumstances come up, or have the client weigh in on whether they want their information disclosed. At the end of the day, though, in my experience, those situations are relatively rare in terms of reporting, where there's a bona fide reason that the client doesn't want the name disclosed. No client really wants their name disclosed, but it's the bona fide reason behind it that is the rarity.
Well, if I could just follow up, I live in a very rural Northeast Kingdom of Vermont, and there's plenty of characters that don't want their name or address or anything divulged for any reason. I mean, as a listener, I've had people basically threaten me to not have an E911 address. Well, again, I think it should be understood as far as, excuse me, what rural characters sometimes we have to deal with. It may be to the detriment of some, rural small contractors or whomever, to not receive a job because they don't want their name divulged. So again, it is a concern.
Yes.
One of the things I heard loud and clear from Representative Hango was this idea that the employer of public servants like us is something that is important for the public to know. And I'm wondering, Director Siverett, if there's a way for self-employed people to kind of get at, who are their employers, without necessarily capturing, every person that, if I build houses, is it important for the disclosure to know like everybody that I did a small reno for, or are we really talking about, do we really want to focus for the purposes of this legislation on the, for instance, like an attorney that works in the legislature that has a client that has business before a commission or, is bidding on state contracts or something like that?
I mean, that's obvious. Those are obviously the cases what they were really trying to get at, not necessarily somebody who is like received a small grant from the state to improve their house and then you're somehow working on it as a contractor. I do think one way to potentially address that is you could consider raising the limit of $10,000 to capture situations where there's more money at stake and you're more likely to not bring in those kind of like smaller situations where you're naming, every client you put in windows for. But again, it's also, you have to know that the client has business with the state. I mean, that's what we're getting at here. We're not asking you to go out and survey everyone. And you also don't have to disclose the nature of that business. And so that's an extra layer of protection here where you're not, revealing only the name. You're not saying why they received money from the state. You're not revealing anything about what you did for them. So it's just the name and no more than that. You may have, input. Sorry.
So thinking about a neighbor in my town who builds homes for a living. And we live near a ski resort. So a lot of people have second homes. We're also on the Canadian border. A lot of people have second homes. What if that neighbor who's the builder builds a home, and homes are not cheap these days. So it's obviously going to trigger whatever threshold we set for a dollar amount for someone. And all we know is the contract that we have with this person. We don't know this person personally who's building the second home. We don't ask questions. Well, what do you do for a living and who do you work for and what contracts have you gotten? What if that person happens to have had business with the state of Vermont and clearly they're well off enough that probably their business is very profitable, and they've actually had a big contract with the state of Vermont, but we the builder, my neighbor, has absolutely no idea that this person got a contract from the state of Vermont, for instance.
Then you don't have to disclose it under the language that is written now. If you don't know, then you don't have to disclose it.
But it almost feels like that builder now has to ask their clients, well, what do you do for a living and what contracts have you had with the state? I mean, what if that comes out afterwards? Then
I think so. According to the language that's here now, that's not something that you have to ask. So I wouldn't feel any pressure to have to ask. If it's something where you have a very, arm's length relationship with this person, you don't know anything about them, then you don't need to do a deep dive into their personal life when you're filling out the financial disclosure form. I understand the concern that later maybe there'll be a perception and that somebody might complain that the financial disclosure wasn't filled out properly because they assume that you should have known. However, in that case, the reason that you're going to give is that, no, I did not know. We had a very arm's length relationship. I did not ask them this question and I was not aware of it at the time.
Okay, so back to my neighbor who's running for the legislature. Sorry, I forgot to say that. That person, what if they do know? And they do know that their client has business with the state, but they don't know the extent of that business with the state. Are they supposed to ask?
No, because
client?
Under the financial disclosure, you don't have to disclose the nature of the business, just the fact that they do have business with the state. Because what you're looking at here is the nature of your relationship. So you understand that they do business with the state, but you don't have to go further than that. For the purposes of this disclosure, you just want to know that they have business with the state. If that's all that you know, then that's enough.
Okay, so then that person, the client who's building the home, why would they want to expose themselves to the public and have the person running for the legislature who's a builder build their house? Why wouldn't they just choose somebody else so they don't have to go through all that and have their name put out there in public? I mean, really, this is an invasion of some people's privacy who have nothing to do with the candidate running for office. Just like I think Representative Hooper might have alluded to a spouse or domestic partner who is not the person running for public office. Why does that person have to have their personal business exposed to the public? What relevance is that?
The underlying reason is that the financial interests are intertwined.
I understand that. However, I think we're hearkening back to the old days when one spouse had control over the finances of another, and that spouse's, and typically it was women, that spouse would be beholden to the husband who had the financial controllings. And I feel like this is going back in time and saying, just because my spouse makes money doing such and such, that's influencing me and my decisions. And I really take offense to that type of situation. And I'm going to go back to the client building the house. Sort of a similar thing. Why would they even want to get involved in this?
Oh, you want to move on?
I really want to move on. So let's make that comment quick. I want to wrap this up, take a break and get on to our next thing. I promise we will pick this right back up tomorrow afternoon, but go ahead, Representative.
Well, again, just to further that, so let's say you don't have to disclose what the person had for business with the state and municipality and all that. Okay, you didn't know. But again, you go back to the next clause, it says you've got to put their name in there as far as the amount. Well, if somebody found that name and they knew that that individual was, and I won't use a name, but somebody prominent in the renewable energy field or whatever, yeah, they could then open up a case, I'm assuming, basically saying that I believe Representative Igley, working for this individual, is now, gonna gain specifically from working for this individual. Then you'd again have an investigation, I would think, into, if somebody else outside, maybe they saw that name and they said, hey, I know who that person is and I know all about him. And anyway,
And I think you're actually getting at the heart of the purpose of the disclosure form is to capture those situations where you have a client where you receive a significant amount of income from them and they have their own personal significant financial interests. And so the idea is to make sure that, there's no conflict of interest in official actions that you're taking. So it's to identify the potential conflict of interest. It's not looking at generally speaking, could you potentially, represent someone's interest? It's if you have a specific course of action in front of you that could affect that person, is there a conflict of interest or the appearance of one? And so then you would be looking into that very specific set of facts, but not something just very general.
So I think what we'll do is push pause on our ethics discussion for today, since we have witnesses coming in already on our next topic. Representative Thurber.
Thank you. If you're ending this discussion, there was still one unanswered question that I had from back when the director was sitting behind me. What complaints that you're hearing are bringing the need for this legislation forward? What specific complaints about people running for the state legislature?
Specifically at the state legislature or more generally speaking?
No, specifically for the state legislature, because we're adding in the piece that state-led representatives.
Yeah, and executive officers. So it'll apply to everyone who already has to file a financial disclosure, not just candidates.
Right, but we're specifically adding in a group of folks, a group of candidates who do not currently exist in statute.
For county officials, you mean?
No, I'm talking about state representatives.
Well, they already have to file financial disclosures, so it's just bringing in it's changing the nature of the information.
Okay, so
For increased
what-
disclosure, but not just candidates. It also applies to executive officers and sheriffs and everyone who already has to file.
Okay, so
this
what
form.
complaints are you hearing that specifically brought those changes forward in this legislation?
Sure. I mean, so there's two reasons we're looking at these changes. One is we're looking to upgrade, our ethics framework right now because Vermont is at a very basic phase. But financial disclosure is very much related to the ideas of preferential treatment, which is would be a violation of the code of ethics, and conflicts of interest and the appearance of conflicts of interest. And that those are the majority of the complaints that we get into our office are related to those two topics. I'd say at least 70%, possibly more.
Thank you for coming. And I just want to go on the record saying I'm all for this. I think it's inherent upon us to get out in front of this, not to wait until there's a problem. I'm all for this. I appreciate the work you've put into this, and I hope we can move forward with it.
We're gonna continue to move forward. I appreciate that, Representative Murwicky. We'll hear staff up tomorrow. I think, I want all of us to, take a look at the draft language, the summary. If there are specific, ideas, concerns, thoughts, I think there's the potential we can clarify and tighten up the kind of, client information that we're looking at. I still think there's a little bit of confusion around that loan language, so I think we might want to dig into that tomorrow, and then when we come back next week, potentially see some changes there. I appreciate everybody wrestling with some of the harder things here, but to Representative Murwicky's point, I think there's a lot of advantage for all of us across state government. And one of the things I wanted to remind everybody from was when we had Jay Johnson, who was really representing the administration's point of view on here, she made it pretty clear that we would not get the kind of support that she was able to voice from the administration if we were only having the increased disclosure requirements apply to the executive branch. So what our task before us, I think, if we're going to maintain that level of collaboration with the administration, is to say what is sort of good universally for all public servants, whether they're in the legislative or the executive branch, and for candidates for some of those elected judicial branch positions, which we've brought in this draft. So those are the kind of things that we'll all need to think about. We do have to switch gears. So I didn't know we would have as robust a committee discussion as we did today, but I think it was really valuable. I know that we'll continue to find us as we work through some of these ideas and some of the pain points that we've identified here, but we'll be back at this with some more testimony and discussion tomorrow. So committee, let's take a 10-minute break.